USCIS has announced a new policy to evaluate VAWA petitions, which is great news because this means that more immigrants will be allowed to apply for a green card through their own self-petition. A VAWA self-petition allows an immigrant to request a 10-year green card on the basis of having suffered extreme cruelty or battery by their U.S. citizen or lawful permanent resident spouse without ever getting them involved or them finding out. You can apply for VAWA whether you are a man or a woman, and through this you may be able to request a work permit, deferred action, a travel document, and your 10-year green card. So, what changes has USCIS recently announced that involves VAWA self-petitions? First is a critical update to their criteria for proving shared residence. Part of a VAWA application requires that you prove that you and your spouse resided together and shared a home during the course of the marriage. You can prove this through certain documents such as a lease, bank documents, affidavits from personal witnesses, school or medical records, or any other document that can help prove that you and your U.S. citizen spouse or green card holding spouse shared a residence. With this new change that USCIS has announced, you now only need to show that you and your spouse have lived together at any time in the past. So now, this will make it much easier for VAWA applicants to get approved for VAWA. For example, if you only lived together with your spouse before you actually got married and after the date of marriage you were unable to live together in the same house, you may now qualify to file for VAWA despite the fact that you did not share a residence after the date of legal marriage. The second change by USCIS has to do with the good moral character requirement of VAWA applications. If you have certain convictions within the 3-year period before your VAWA application is filed, you may have a bar to being approved for VAWA. However, an exemption to this does exist if you can show a relation between the abuse that you have suffered and this criminal conviction. The recent announcement by USCIS actually broadens this exemption and makes more criminal convictions eligible to be waived for this requirement. Why does this matter? In domestic violence situations, it is not uncommon for charges to be brought against both parties, even if only the abuser is the one who has perpetuated the crime. This may result in VAWA applicants in having charges brought against them needlessly. The government understands this and allows charges that are connected to the battery or extreme cruelty to qualify for an exemption so that the person who has suffered abuse can still meet the good moral character requirement. And the third change announced by USCIS allows stepchildren and stepparents to be eligible for VAWA self-petitions even if the parent and the step-parent got divorced. For example, if you are the child of an immigrant and you come to the U.S. because your parent married a U.S. citizen, the U.S. citizen then becomes your step-parent, and over time, you may suffer extreme cruelty from them. If later your parent and your step-parent divorce, you may still qualify for VAWA even though the U.S. citizen is no longer married to your parent, so long as you meet other VAWA eligibility requirements. USCIS has announced that they are implementing these changes effective immediately, and they will be applied to all VAWA self-petitions that are currently pending or that are filed on or after February 10, 2022. If you think that you may now qualify, please give me a call at 212-248-7907 so that I can go over your case and see how we can proceed. If you want to learn more about VAWA and how to file and who qualifies, I will leave a link to my other videos that go into more detail about VAWA applications. I will also continue to bring you more news and information about VAWA, so be sure to subscribe and turn on the notifications if you have not done so yet. Click here to watch this next video, and I'll see you there.